A very good morning to everyone present here. I request everyone to kindly keep their phones on silent and wear their masks properly. Please cover your nose as well. I welcome our speakers for today, Professor Dr. C. Rajkumar and Professor Sudarshan Ramaswamy. I also welcome our beloved Principal Dr. J.M. Mallikarjunaya sir, our IQAC Coordinator Dr. Manoj Kumar V. Hirimat sir, and all the faculty and staff, all the faculty and students present here. The KLE Society's Law College is happy to be organizing today's expert talk on legal and constitutional foundations of public policy towards promoting good governance in India. Our first speaker for the day, Professor Dr. C. Rajkumar, a Rhodes Scholar and the founding Vice Chancellor of O.P. Jindal Global University, is here. Along with another visionary of our times, Mr. Naveen Jindal, Professor Kumar established JGU in Sonipat, Haryana in 2009. He is an accomplished legal scholar who has worked extensively in the fields of human rights and development, comparative constitutional law, terrorism and national security, corruption and governance, etc. He has published 7 books and has over 150 other publications in internationally reputed publishing houses. He has also contributed articles in newspapers and magazines published from Hong Kong, India, and the UK. He was awarded the coveted Rhodes Scholarship at the University of Oxford, where he obtained his Bachelor's of Civil Law, and the Landon Gammon Fellowship at the Harvard Law School, where he obtained his LLM, and the James Sovereign Gallo Memorial Scholarship at Harvard University. He also received the Doctor of Legal Sciences from the University of Hong Kong. Professor Kumar has served as a faculty member at the School of Law of City University of Hong Kong for several years. His expert views have been consulted by various international organizations like UNU Tokyo, UNDP, ICHRP Geneva, etc., and even the NHRC in India, on issues relating to human rights, corruption, and good governance. He is an attorney at law and is admitted to the Bar Council of Delhi and the Bar of State of New York. We welcome you, sir. Our second speaker, Professor Sudarshan Ramaswamy, also a Rhodes Scholar, has been the founding Dean of Jindal School of Government and Public Policy since 2012. He has completed his master's degree in economics from Delhi School of Economics and obtained a degree in politics from Balliol College, University of Oxford. He was elected to a research fellowship at St. John's College, University of Cambridge, specializing in the interface of law and economics. He was a visiting scholar in the School of International Development, University of East Anglia. He has served as assistant representative in the Ford Foundation South Asia office and as a program officer for the Human Rights and Social Justice. Professor Ramaswamy has served as a policy advisor for UNDP in India, Jakarta, and the UNDP Oslo Governance Center, to name a few. He also has numerous books, articles, and policy reports to his credit. It's a pleasure to have you here, sir. I would now welcome Professor Kumar to give his insights on today's topic. Thank you, sir.
A very good morning to all of you. Very good morning to all of you. First of all, I would like to extend my heartiest greetings to all of you. I don't know how long you have been having physical events of this kind, but it's such a pleasure for us to be here because it's one of the, probably the most recent opportunities since March 2020. We have begun to visit places physically and having this type of lectures and talks. So personally, I'm very delighted to be here. I want to thank our distinguished principal, Dr. Mallikarjunaya, but also other colleagues, Dipali, Kavi Shankar, Manoj Kumar, and also other faculty members and students who are present here for this talk that we intend to give. My colleague, Professor Sudarshan, and I, Sudarshan is a very distinguished expert on public policy, and I work on the interface of law and public policy as well. And I'm happy that my friend and former colleague, Professor Padmanabha Ramanujan, is here. So the topic of today's talk is on legal and constitutional foundations of public policy and towards promoting good governance in India. So let me first, give a little bit of perspective about what public policy attempts to achieve. Now, many students might be aware that public policy and public administration are used a little bit interchangeably, and there are good arguments why they can be used interchangeably. But I'm of the view that there is something about public policy that actually transcends the idea of public administration. And that aspect of public policy is much more closely connected to the ability of legal institutions, constitutional frameworks, laws, rules, regulations, procedures, processes, mechanisms that are involved in essentially governing a society. And that makes public policy slightly different, and I would say, and I would consider to a large extent public administration as a subset, although an important and a large subset of public policy itself. So why it is important for law students and lawyers to understand, appreciate, and be conscious of public policy making? Well, the most important part of this, the reason is that public policy essentially creates that framework for building even institutions and procedures and design that would enable the governance of any society. And many a time what ends up happening is that policies get designed as a part of the executive responsibilities of the government, and many a time policies are implemented by the government, sometimes, as you know, as a part of the executive decision. A cabinet note or something gets circulated, and the government draws its powers through that exercise. Many a time it gets announced as policies of a particular department or a ministry, department in the state and ministry in the central government, and they end up getting implemented. But there are also occasions when policies are backed by legislation, and that also could be a parliamentary legislation in the case of the central government and a state legislation in the case of the state government. Now, it's always a very interesting question, both of law and policy, that what are the what are the ways by which a government can and should determine when the policy that it is formulating and attempting to implement requires a backup of a legislation. And very strangely, there are no set rules about it. And what ends up happening is that many a time these matters, when it actually ends up getting implemented, they potentially raise a lot of legal and constitutional issues. And when it comes to adjudication, courts are most often asked to adjudicate as to on what legal and constitutional authority such a policy is implemented. So that's about the first legislative or executive capacity to formulate a policy of that kind. And second, more importantly, the courts are even asked to adjudicate whether a policy that actually gets formulated and implemented is in violation of an existing law or even the constitution. So, in some ways, the less studied aspect of legal education and lawyers, not just in India but also around the world, is this entire aspect of public policy. And unfortunately, law schools don't tend to give adequate attention to public policy, because a lot of what we study in law schools has a very strong connection to what the courts do. It's almost like if the courts are not coming into the picture, our case study method that we adopt, and even the common law system from which our own principles of law have evolved, we are so much focused on court-centric approach towards legal education. And I'm not saying it's a bad thing, but there are other things that need to be paid attention to. So the first and most important point I want to make is that public policy and the study of public policy is absolutely critical for every lawyer, every law student, every law professor, and of course every judge. The second point which I want to make is that uh, as you think about public policy, you want to first of all consider to what extent public policy making can effectively contribute to good governance. Because ultimately, both law and policy's goal and objective is to promote and facilitate and enable good governance in a society. So that aspect of good governance that we are talking about, and you can use other words, governance, some people have argued is a kind of a fancy World Bank promoted terminology, and you can use administration or management and things like that. But again, governance encapsulates many other aspects of it, and good governance adds kind of an adjective that looks at certain elements of good governance, including transparency and accountability and inclusion and things like that. But the point I'm trying to draw your attention is that public policy requires a much deeper understanding of law and constitution, and to what extent both are shaping the evolution of public policy. And I think it's equally important and not to assume that every policy does not require a law to back it in terms of a new legislation or, for that matter, a constitutional provision. The governments, both state and central, are on many occasions duly empowered to use their legislative authority, their executive authority, to advance the cause of public policy making. Now, where the blurring of the power of the government to engage in public policy making on the one hand, and the power of the courts to intervene on whether the policy has been made A, in consonance with laws and existing laws and rules and regulations and constitution, and B, whether the government has the adequate power and authority to make policy in a particular space. It raises issues surrounding federalism, for example. It also raises to what extent the capacity of the government is in exercising powers in a particular domain. So in a way, as law students, it will be a very useful exercise for us to look at what are the legal and constitutional foundations of public policy that are more effective. Now, I think the reason it becomes important to ask this question is that law and the ability of any legal framework is to provide a certain degree of certainty, predictability, fairness, and ultimately help in achieving justice. These are attributes that law would bring to the idea or notion of public policy making. Public policy in its natural sense, without reference to law and constitution, potentially may not add these attributes in its own right. So in a way, it recognizes the need for keeping these aspects in mind while you are making policy. Now, one of the large influences in the broader discipline of public policy that has played a very significant role is economics, and arguably contemporary public policy makers or people who work in the field would even argue that sociology and political science and other anthropology and other such disciplines, ethics and philosophy, might play a very significant role. But as a lawyer, and I know that I'm talking to law students, I strongly believe that legal institutions and legal structures and constitutional processes do play or ought to play a very significant role in public policy making. And that is why we need to look at the legal and constitutional foundations of public policy. I also want to mention that while the legal framework does not provide all answers to policy making, what it does is it creates mechanisms for dispute redressal while policies are made and policies are implemented. I mean, it is of course so obvious to recognize that any policy in the process of its implementation is going to lead to a certain degree of dissatisfaction, grievances, and even people being affected and impacted by the policy. It's not good enough for us to say that, and that's a typical argument that has been used sometimes even by courts, that it is not our domain to question, let's say, economic policy. And there are numerous judgments which have time and again talked about it. But it's a much more, and when you take this question to the next level, which I want to ask you, which a lot of academic writings and scholars have written about it, which is that are judges involved in making policy? Question. Are judges involved in making policy? Anybody? Anybody? Any answer? You can say yes or no. Yes, okay, all right. And is there anybody who says no? Should judges be involved in making policy? So most of you have said judges are involved in making policy, and most of you are also saying that judges should not be involved in making policy. Well, let's make it simple. And the first point is absolutely right. Whatever way, whether we like it or not, judges are of course involved in making policy, and they do it in different ways. And of course, in India, enough provisions in the Constitution, particularly Article 142, which talks about doing complete justice, has been used and occasionally abused to do all kinds of things by the courts. Of course, we have the writ of mandamus and other provisions in the Constitution which have been invoked for the judiciary to intervene on so many matters which are involved in effectively policy making. But for even the judiciary to intervene on matters that are in the domain of policy, it's absolutely important for it to recognize that the legal and constitutional foundations of policy need to be impacted, need to be violated in some form, need to be redressed, and that is the reason for the court's intervention. Good judges take enormous effort to justify that intervention, and some others do not do that and end up making it so obvious that they have all the powers to do whatever they like in the context of intervening on policy matters. But the point which I want to bring to your light as young law students is, you want to actually start analyzing the role of the courts when it comes to intervening on policy matters. What constitutes policy and how the court starts intervening when it comes to policy matters. One very interesting example, which I'm sure you're all aware of, is that one of the early criticisms of the Aadhaar card was that Aadhaar card as the unique identity card was brought into the public or rather as a public policy without a strong legislative backing. Now, as a constitutional law scholar, I would easily argue that you don't need a law to back up for having a unique identity card, because if that argument is taken to its conclusion, there are inherent powers within the government to do so many things, and having an identity card for each individual in the country may not necessarily require legislation. But you can also equally make an argument that insisting on an identity card for availing certain services within the government for access to people, that insistence may potentially violate fundamental rights, including Article 14 equality, and create a more arbitrary exercise of power, and hence that absence of legislation can potentially undermine the very objective for which the law was originally needed and was not brought in making the unique identity card. Now, this is of course a nuanced distinction which probably law students and lawyers tend to understand better. But the point I'm trying to say is that public policy requires more nuanced distinctions when it comes to exercise of powers by the government, but also under what circumstances those powers could be evaluated and even responded to by other bodies such as the courts. Let me quickly move to what I would call the constitutional foundations of policy making. Now, here there is a vast territory within the Indian Constitution which gives enormous opportunities for the government to do many things. For example, if you look at the entire chapter 3 and chapter 4 of the Constitution, both the fundamental rights and the directives of state policy, the ability of governments, state and central, to advance different forms of public policy can be justified very effectively when it comes to using those provisions. But the question that we as lawyers need to ask is that to what extent the government's role in advancing policy making should connect to the constitutional powers that are vested with the government on the one hand, and secondly, to what extent the violations of a power exercised by the government in making a policy has a direct impact on the fulfillment of fundamental rights of an individual. These are issues that constantly come before courts. But as lawyers, when you are looking at many aspects of decision making, start thinking in terms of how policy is impacting the exercise of powers on the one hand, and to what extent public policy is also impacting the role of institutions that are involved in exercising different forms of power. I want to conclude and invite my colleague, Professor Ramasamy, is that the reason law professors, law students, lawyers and judges need to become far more sensitive about public policy is that it is no longer possible for governments to undertake only legislative route or constitutional amendment route for making policy. They should have the state and its powers have expanded quite significantly. The demands and expectations of the government or of the people upon the government is quite significant, and to actually impose so much of transaction cost on the government for implementing every policy or formulating every policy, there has to be a new law to be made or an amendment to the constitution needs to be made, actually creates a significant amount of inefficiency in the functioning of the government. I think the problem comes when more and more arbitrary exercise of powers by the government leads to people having lesser faith and trust on the ability of the government to make effective public policy that is in the best interest of the public, which is on public interest. So as law students, it's important for us to provide guidance, even a critical evaluation of policies, so that to what extent public policy can help in improving the quality of governance in India. With those words, I'm going to stop here and invite Dean Sudarshan. As it was mentioned, I'm sure somebody will introduce, but to save time, I'm going to quickly introduce him. Dean Sudarshan is the Dean of the Judicial School of Government and Public Policy, spent 22 years at the United Nations Development Program, UNDP, spent a decade at Ford Foundation. He is a homegrown Bangalore boy. He studied in Central College here in Bangalore, after which he did his Masters from the Delhi School of Economics in University of Delhi, after which he was a Rhodes Scholar, studied his Master's degree in Oxford University and spent several years in Cambridge University pursuing research on an aspect that is very closely connected to what I just said, and I'm going to invite him to continue this conversation, and then we'll take questions towards the end. Thank you very much.
Thank you very much, Dr. Rajkumar, and thank you, Principal. And I'm very happy to be here addressing you. Vice Chancellor Rajkumar made a very strong case for why lawyers and law students should take an interest in public policy. As the Dean of a School of Public Policy, I endeavor to get my students to appreciate why they should learn law, because of the intimate connection between law and public policy. So we have quite a few courses that enable our students, or public policy students coming from many disciplinary backgrounds, to at least get a good grasp of constitutional law, because it is undoubtedly a foundational element in policy making. But what I want to dwell upon here is that it's not the case that in every country in the world there is the intimate connection between constitutional law and policy making as there is in this country. Dr. Rajkumar made a reference to the provision in the Constitution that empowers our judiciary it's got the widest jurisdiction of any judiciary in the world, and it enables the judiciary to do things that it may arguably say is in the interest of doing complete justice, and therefore the Constitution of India is in a way different from the constitutions of many other countries. For one, we were the first constitution after World War II to incorporate into the Constitution a chapter that is titled Directive Principles of State Policy. And this idea of directive principles is actually not a common law idea at all, because in the common law world, Parliament is supposed to be all in all, sovereign and representing the sovereignty of people, and you couldn't, there is no constitution in the United Kingdom, so there is no prescription of policy as a constitutional feature, whereas in our constitution, policy is prescribed in the directive principles of state policy. Now this is an idea that the Indian constitution makers took from the continental tradition, the civil law tradition, the Napoleonic codes and that tradition, and incorporated in our constitution what are called principles that are fundamental in the governance of the country. And so that makes our constitution a programmatic constitution. It's a constitution that doesn't simply say what different parts of the government, what different institutions of the state, what are their powers and what are their limitations. That's what usually constitutions do. But our constitution goes beyond that. The United States Constitution doesn't have anything like the directive principles of state policy. Our constitution is a programmatic constitution. It's a program to transform India. It's a constitution that looks upon all entities that are constitution parts of the state to engage in the transformation of this country from what you might call a homo hierarchicus, a hierarchical society, to a more egalitarian society. And that's a very revolutionary vision in the Constitution. And to that end, it prescribes a number of things the state ought to do. Now you could argue, say, you have elections, people elect a government. Why do you have to prescribe in the Constitution itself certain fundamental principles? Why can't you, like the United Kingdom, leave it to the electorate? One party says we will be more market-oriented, and if the public and the electorate feels that's what's needed, they will elect them to power. Another party might say we are more socialist and more state-oriented, in which case that party persuades the electorate to elect them to power, and they will bring into force whatever they have said in their election manifesto, which is part of their political ideology. But in our case, that's not the case. In our case, the Constitution itself has, for all parties, for all time to come in a way, prescribed policies. So this makes it very important for anyone studying law or anyone studying public policy to take a serious interest in the interface or the interplay of both disciplines, viewpoints from both. And there's another reason to do this, because conventionally policymakers have a tendency to think in terms of what I might call all, more or less. I'll give you an example, the Income Tax Act, right? It says if your income is more than 100,000 rupees, your tax rate is X. But if your income is more than 500,000 rupees, your tax rate would be maybe 2X, right? Now, where you draw the line is completely arbitrary. It could be 150,000, it could be 175, 130. But at some point you draw the line and say, so this is what I mean when I say more or less, right? So you pick on this and say so the policy is that someone who is earning a lot of money ought to pay more to the public exchequer than someone who is earning less. That's the underlying principle that can be justified, on grounds of political philosophy, in terms of, moving towards a more equitable society. You have this. But the training of lawyers and judges has been that, because they don't pay attention to policy necessarily, is everybody is equal under the law, and therefore the mindset is one of all or nothing. Everybody has a right to property, or no one has a right to property. If you say there is a right to property in the Constitution, then everybody has it. Maharaja Kameshwar Singh of Darbhanga, the owner of huge estates, who and his ancestors were compradors with the British, who exploited tenants and took revenue from them and paid part of it to the British government under the zamindari system. He has the same right to property as a small peasant who may have half a hectare of land trying to make ends meet, right? So this is the attitude of and this created our first problem. The first problem in our Constitution, even before the ink was dry on the Constitution, was that even before the Constitution came into force, Zamindari Abolition Acts had been passed by many states. But after the Constitution came into force, and it inserted in the fundamental rights property, the courts took the view the property of all of the zamindars is also covered by the right to property, and the right to property means that if the state takes it over, it should give something that is a fair equivalent in return. Now so we went through all the processes. We thought the problem is that the Supreme Court, Patanjali Shastri, is interpreting the word compensation to mean market value or fair equivalent. Let's take the word compensation out. Let's put the word amount, an amount prescribed by law. We did that through a constitutional amendment. But the courts held whether you choose to call it an amount or you choose to call it compensation doesn't matter. It is a right to property, and the right to property means taking away property, means replacing that with a fair equivalent in monetary terms. So then we went through all these hoops, and we unfortunately created a 9th schedule in the Constitution to protect zamindari legal reform rights, land reform rights. And that was a bit of a dangerous thing to do, because it's like, and again, that was not a very original idea, because you see we borrowed directive principles from the Irish Constitution. But then when we got into this problem, where the courts are saying the zamindar's property is equivalent to a humble peasant's property, it's right to property, everyone has it. Policymakers don't think like that, right? You think that a rich person should pay more tax, a poor person pays no tax, right? Now that's the policymaker's mindset. The judicial mindset is right to property, everyone has it. So we created the ninth schedule to protect these laws, and in the process, we created a schedule which says any law placed in the schedule is immune from judicial review, and we witnessed legislation that should not have been placed there, like the Maintenance of Internal Security Act was placed there, and therefore that was a phase of our history that all began with a problem. The problem was that the mindset of lawyers and judges was fixed on this all or nothing. The mindset of the policymakers, more or less. Now, if only the courts, the judges who heard this, had thought about policy aiming to achieve. This policy is aiming to achieve equity and justice. This policy is aiming to take land from a set of people, a very small set of people, who throughout decades had exploited their tenants and the persons who actually till the land, and do justice to them. And therefore, you cannot expect that they will be made rich in some other form when you redistribute the land. Now, this is a, if you say law, the purpose of law is to advance the cause of justice. Our courts should have said, this is the aim of this policy, we will uphold it. But if you mechanically say, Article 14, everybody is equal, equal opportunity, everybody is equal under the eyes of the law, right to property applies. So the consequence of that is that we now no longer have the right to property in our fundamental rights chapter. Successive governments have felt this is a serious problem, and they've relegated to another constitutional provision. Whereas, and the consequence of that is that today, a humble person with very small property would have enormous difficulty contending with the state in terms of the state taking over, right? And the state's definition of public purpose could be anything, right? It could be that you want to take vast amounts of land and give it to very large capitalists who want to make huge amounts of money or favor multinationals, and this poor peasant's land is taken up, and he says, look, if you want, go to some court and wait for decades because it's not a fundamental right anymore. There is no power of writ that a high court or a supreme court can issue, right? So this is a lesson that this is a good reason why law students must be sensitized to what is it that policymakers are trying to achieve. Because in a way, it's difficult to separate, policy making and all. Most, it could be an executive act, but even any executive act like imposing a fine for not wearing a mask, it may not require legislation, but it will come under some legislation which, whether it is the Motor Vehicles Act or some Road Transport Act or Public Safety Act, something like that would give you the executive power as well. So all policy has to be backed by law if the policy is to be enforced. You cannot, without showing, a law. In the way, incidentally, China is trying to develop the rule of law culture. Earlier, the Chinese, if you said bad things about the government, that be the midnight knock, they'll take you away for political re-education, interrogation, and there was no recourse. Now the joke is that China is sensitized to the rule of law. So in the Chinese constitution, the only reference to the Communist Party of China is in the preamble. Other than that, there's no legislation that governs the Communist Party of China. The preamble of the Chinese constitution says the Communist Party of China is the leading institution of the state. That's all, leading institution of the state. So otherwise, there's no backing for the party in law. So the joke now is that the guy comes along and knocks on your door, and you open the door and you say, why? You say, sorry, we want to take you for interrogation. And you say, under what law are you taking me for interrogation? And the answer to that is, under the preamble of the Constitution of China. Right? So you can see that this rule of law requires you to have, for any act of the state that interferes with the liberties of citizens, you need the backing of law. That's a very good principle But there ought to be, in terms of how you do this, more sensitivity. In fact, originally, there was no such thing as judicial review. The United States Constitution didn't contemplate judicial review. And we all know that judicial review came about as an act of political expediency. You may know that the problem was that John Adams left as president and issued a series of appointment orders for appointing judges to federal courts, but those orders were not dispatched from the White House, and he demitted office. Jefferson becomes president. Now Jefferson says, I don't care for all these people who have been appointed by John Adams, they're not my kind of people, so I will not issue these appointment orders. So then there becomes John Marshall, the Chief Justice, who knows that Jefferson is a very powerful president, I mean one of the architects of the US Constitution. You don't want to take on him because he would say, you know, how many divisions does the Supreme Court have, right? There's no power that way. So what he did was to find a beautiful solution, which is to say, yes, you know, those appointment orders were legitimately, legally signed by the previous president, and they ought to have been dispatched. However, those jobs themselves ought not to be there, because under the Act, the Justice Act of the Congress, these appointments could not be made. They are in violation of the Constitution, right? So both, that the president's appointment letter should have been sent, however, they are for appointments that are not there in the Constitution. Those jobs should not be there. By reading the act that created those jobs violates the definition of powers of the constitutional powers to create positions in the federal judiciary. It has to do with, it's limited to ambassadors, and some limited number of posts could be created. So this is what John Marshall did. Now this was done as an act of political expediency, mind you. So the power of judicial review is intimately connected to managing politics, right? So there's no getting away, not just policy and law, there's no getting away from politics. You know, it's all law is imbued with politics. And so one great example, I'll finish in a minute, where after judicial review came into existence, you got courts inevitably involved in policy. Roosevelt, to get the United States economy out of the Great Depression, passed a series of legislation which is called the New Deal laws, including good things like limiting the hours of work for, say, women to 45 hours a week, because long hours of work, and you all know that March 8th, because on March 8th there was a movement, a strike of garment workers in New York protesting against their working conditions and their exploitation by owners of the garment factories, making them work long hours, giving them no overtime worthwhile, and so on. So the courts held, no, but there is the freedom of contract. If a woman agrees freely of her own will, as if it is free, right? You are forced by poverty and circumstances to agree to an unequal contract, but in principle it is supposed to be voluntary and free. The state should not interfere with the freedom of contract. Now this was the position of the law until you got a brilliant lawyer, Brandeis, who produced evidence. Policy is supposed to be evidence-based. So he produced the evidence for the law restricting the number of hours of work for women by pointing out how long hours of work damage the health of the woman, it damages the health of the child that is born, and it affects successive generations. And therefore this documented evidence, which is now known as the Brandeis Brief, which is really the evidence for the policy. Now the courts took cognizance of that and reversed the original position of freedom of contract and said, yes, you know, there is good justification for this policy. We will uphold it as valid under the constitutional provisions of the court. So we have in our public interest litigation followed the same example. In other words, the court asks a group of experts or creates a commission and says, bring us the evidence which will justify our position in making a declaration under the law as to whether the abolition of bonded labor is valid, whether you should take action to protect children working in carpet industries or any of that, right? So this is how evidence comes into court, by the use of something which in the USA is called the Brandeis brief. We may call it whatever we wish to, but this shows the intimate relationship between law and policy, and it means that when lawyers and judges ought to broaden their minds and not think narrowly in terms of all or nothing, or narrowly as a black letter lawyer interpreting the law, to have our Constitution requires a teleological interpretation of its provisions. A teleological interpretation means what end or goal or interest of justice is this provision meant to serve, and is the policy that is before us, that's being questioned before us, serving that end. Not worry too much about the grammar and the English in which it may be written. If you write the same thing in some other language, it probably would mean something else. So we can't be, victims of the fact that our Constitution and our judges and our courts are conducted in this language, in English. The same thing written in French and German may mean different. If it's written in Kannada, it may mean something different. So there's no great sanctity to the words in the language. What has sanctity is the teleology. What is the purpose of this provision? So if we begin to think like that, there wouldn't be this tension between the executive, the legislature, the policy makers, and the judges on the one hand, and we get better public policy and citizens better. Thank you.
Thank you. It was rightly pointed out by Honorable Vice Chancellor Sir that we have missed such public engagements for too long now. This is reflected in our Principal Sir's decision to get not just one but two distinguished legal luminaries to deliver this expert talk. This was indeed an engaging, enriching and a thought-provoking session which may have quelled our older doubts and curiosities but given us much to think about and newer curiosities. So without further ado, I would now open up the session for putting up those newer queries and getting answers from the experts themselves. The mic will be given to anybody who raises their hand for.
Good morning, sir. Sir, the question that I got was, while discussing about public policy, you pointed out how public policy makers are thinking about equity, while judicial lawmakers are thinking about equality. So, sir, how does one bridge the gap between an equitable government and an equitable governance and an equality-based law or a policy?
Yeah, no, this is going to be a perennial problem. It's not going to be solved quickly. So what ends up happening is that when governments are using very strong political arguments to justify what they are doing, they inevitably, it will help them to draw upon the legal and constitutional framework for advancing that public policy. Ideally, what should be the case is when, in fact, courts are, if you look at what courts are doing, courts are mostly using the whole, the EP Royappa versus State of Madras, if I remember, that argument about arbitrariness as for, and using equality and arbitrariness, Bhagwati's judgment for most of these, declaring them as unconstitutional. So long as there is sufficient information out there that the government has, gone through a process for formulating a policy, even under, let's say, consideration for equity, the court will not interfere. And in fact, there are very good indications. For example, if you look at the Manrega scheme, if you look at many other social welfare legislation, and those legislations have been challenged in different courts, and courts are not inclined to do it. So in a way, the point which I think both the legislature, the executive, both of them need to be conscious of is that there needs to be a much deeper analysis, including rationale for advancing public policy, even with the objective of promoting equity. And this is on the question of people who are from legislative and executive. But when it comes to judiciary, I think judiciary is also need, and if you look at the whole coal block allocation case, the 2G spectrum and all these cases, now courts have become much more conscious of the fact that where they should intervene. They cannot go into a sort of assume that if certain acts have been done by the government in its wisdom, all of them need to be once again reassessed on the basis of some people coming before the court. In fact, I strongly believe that the SR Bommai test continues to apply, very important test, which is the words used in that judgment was the court should examine whether there are judicially manageable standards. These are the words that the judgment uses, judicially manageable standards when it comes to assessing whether the court is able to look at the acts of the executive. The unfortunate part is that increasingly courts tend to, when they end up responding to different forms of allegations or even information or reports or whatever, that type of nuanced, rigorous research backed by evidence at times gets lacking. So we need to take that responsibility much more seriously. And here I must say that one can have a slightly different yardstick when it comes to violation of civil and political rights. Say, for example, if in writ of habeas corpus, for example, you may not have the time and luxury to do the research, and you might want to intervene pretty quickly. But when it comes to deciding, economic decision makings by the government of the day, there your intervention has to be much more thoughtful and much more evidence-based.
That's fine.
Very yeah, I know.
Any more questions?
Yeah.
If I may. So, my first question is to you, sir, wherein you had talked about the necessity of the power to be granted to the executive to make decisions for the quicker government implementation. So my question is that if you remember the Barack Obama period in America, where he wanted to bring in gun control legislation and he wanted to use executive power of a president, it was frowned upon there. And even in India, whenever there is laws which are brought by ordinance power, it is frowned upon. So what is your opinion on that?
Yeah, sure. I mean, listen, there is enough jurisprudence developed on account of when you want to bring ordinances and when you don't. And for me, the point was not about expedited legislation. For me, the point is about government. There is a lot of expectations from citizens as to what they expect from the.
Sir, I have, due to a paucity of time,
We'll take one more question.
one more question.
Do you think public policy which is brought into action for the benefit of the society as a whole is justified, even though a particular group of individuals or a group of particular person is harmed because of that policy? Like for example, Sudarshan sir said previously that peasants, the land of the peasants were taken in order to give it to the industrialists for the development of the country. Do you think that policy is justified, even though the particular group of individuals are harmed during that because of that policy?
Sure. So the first and foremost aspect in this is that if these were decisions taken by elected governments on the basis of the powers that they have, and those decisions, there is not enough indication of on the part of the judiciary at the time on the basis of the facts it has, because in a way the biggest problem we end up will face is that who decides what's the right thing to do? Because if you end up allowing, or let's say accepting, courts to interfere on matters that are, the political process will get weakened. In fact, I'll give you a very classic example. If you remember the farmers' protest in Delhi, I will say this. The court, the Supreme Court of India, could not find a solution for the matter. And ultimately, it was a political solution that ended up today the farmers' strike being called off. So in a way, what I'm trying to say is, coming back to the SR Bommai question, which is that courts are already flooded with too many issues that they are dealing with. I don't know whether you know this, but just before the pandemic, there were 3.5 crore cases pending in Indian court. The Chief Justice of India just a few weeks ago said that today, after the pandemic, we have nearly 5 crore cases pending in Indian courts. So in a way, we simply cannot afford for our courts to intervene on any matter that is brought before them and are making an argument that this requires their intervention. I agree with you that if the court is sufficiently convinced on the basis of certain determined tests that a serious wrongdoing has happened, a serious violation of law has happened, a serious violation of the constitutional provisions have happened, then by all means court should intervene. But this should be a very carefully thought out, determined exercise so that we are able to and so ultimately in all these cases, if you see, it is not taking the matter to its logical conclusion. 2G is a good example, and there's every reason to believe that some other cases where the courts intervene will also end up in that situation. And we have to make a distinction, and this is where, by the way, and I will end with this, that the law and economic analysis will also need to come into play. We are talking about criminal law, invocation on matters which are, economic decision-making processes. Europe and North America and many parts of the world have come a long way in not using criminal, justice system in interventions on these matters, and law and economic analysis will provide us with better solutions and in a more efficient manner.
Now, there's a tendency in all courts all over the world, if there's a very knotty, difficult political problem, the political class would like to judicialize it and pass it off to the judiciary. We've done that in the case of Ayodhya. For years and years, no political group as a consensus in Parliament was able to take a stand on it. So they passed the buck to the judiciary. Now they were very grateful to the judiciary and to the Chief Justice for having bailed them out of that problem and rewarded the Chief Justice, as we know. But the danger in doing this is if you judicialize political issues, you are going to get in the bargain a strong impulse to politicize the judiciary. Right? So I think it's important on both sides to be aware of this. Now, with reference to your problem, for instance, the CPM government took over land and handed it to Tatas to make the nano car. Massive protests. Then the subsequent government and the electorate, they changed that, and so the plant went to Gujarat. Now there, it's not on the direction of a court, right? You're dealing with an issue, right? and it's a political issue and political problem. So the United States Supreme Court has tried to stay away from what it called the political thicket. That's the term that the US Supreme Court used very wisely. Not that it's always followed that advice in itself, but this is a perennial problem. The tendency of the political class to judicialize certain issues so that they can say, or even to prevent debate in Parliament on an issue that ought to be debated by taking the excuse it is sub judice. Now that's nonsense. Parliament, you should be, the constitution says you can say anything in Parliament. And anything said on the floor of Parliament is not to be taken up in defamation or anything of that kind. It's a privileged place, right? But in a privileged place, ministers say, we will not answer this question because we will not discuss it because it's sub judice. Now this is making improper use of the judiciary. Sub judice doesn't mean that, right? Sub judice doesn't mean you cannot discuss the merits and the pros and cons of a particular issue. The legal process may take its course. It doesn't, bar a newspaper from writing an editorial, giving its view on what should be decided by the court on a matter. You can't say the editor was wrong because the judges are seized of the matter, so all of us should shut up, right? So we need some, judgment in these matters.
I just want to add one more thing that's why this question that we are discussing is going to be a perennial issue and we are not going to, but we should discuss them. The US court example is very good, but if you remember, in Brown v. versus Board of Education, the US Supreme Court and otherwise court which is much more reluctant, they were involved in determining bus schedules, where the buses will go, about how to ensure that blacks and whites will be able to sit in the same schools, and that type of detailing, what many a time Indian courts are very comfortable in determining all kinds of governance matters. So in a way, the issue of law and public policy and questions surrounding it will be of a constant part of discussion. But in a way, it's important for both for the healthy, frameworks between the three wings of the government and to empower the decision-making processes within the government. The courts ought to be far more differential when it comes to policy making, but at the same time, when it comes to violations of human rights and civil liberties and issues surrounding it, the courts need to be much more proactive. One of my own concerns is that the courts tend to be far more tolerant when it comes to issues surrounding human rights and civil liberties, and far more activist when it comes to economic decision making. Thank you.
The interactive session was equally intriguing and enriching. We thank you, good sirs, for allowing us a sneak peek into your wealth of knowledge. Now, without further ado, I request our guide, philosopher and guardian, Principal Sir Dr. J. M. Mallikarjunaiah, to kindly deliver the presidential address.
Professor Dr. C. Rajkumar, our beloved and honored guest always of KLE family, and Professor Sudarshan Ramaswamy, my dear colleagues and student friends. At the outset, I must express my deep sense of gratitude to Dr. Rajkumar. As always, this time too, without forgetting, he remembered us and took his time out to come visit us and be amidst us to incite and influence the young minds and the faculty all alike about a very growingly important and trending subject, I should say, called the public policy. Since two scholarly professors in law have spoken on the topic, they did bring home their vast learning and experience. I may not be trying to pass any conclusive remarks on that. I'm sorry, we have amongst us our friend Padmanath Ramanujan. Happy welcome to you. Well, quick reflections on this occasion, which of course few of them I learned from today's session too. Public policy is something which is not foreign to any law student. Each of us know it and understand it in different senses. If we don't understand what exactly it is, one thing we have understood well, that is, it is a conundrum, it is a fluid concept, it's not definable, it can at the best be explained in some sense. Today, that profound topic has been spoken about, especially about the legal and constitutional basis of public policy. I am happy and I'm looking forward for an opportunity from this program. The opportunity is, it may not be an exaggeration if I say, this day may become historic for the reason that some of the public policy experts may emerge from the audience, and I wish that to happen.
I hope so.
That being the very important subject, growingly important subject. All that we knew about public policy, as I said, I was also trying my best to tell my students in all my classes with the test that I fondly refer to, like whatever is in advancement of public good, whatever is in advancement of public good, whatever is in suppression of public mischief is public policy, is what I used to say. Then the question is, what is this public good? That is another vague expression. And there I used to tell my students, public good is to be realized not by reference to law. Your legal learning has to be bundled up and kept aside if you want to understand what is public good. As a man of ordinary prudence, representing the common sentiment of the society, you must see what is public good. Having so decided what is public good, you should further check whether the present action is in advancement of public good also, and also suppression of public mischief. And I used to mention this and stop at that. I was very curious when Professor Sudarshan Ramaswamy was in a way advancing a very convincing argument that at least in Indian society, public policy cannot be argued as a fluid concept. It cannot be argued as a conundrum. There is whole policy available in Part 4 of the Constitution. Of course, the Part 4 sets high goals. As such, the innovative interpretations of Part 4 again go to become fluid. But however, there is a guidance, sufficient guidance available in the very Constitution itself. Very well justified, sir, by bringing that idea to the home, especially when we are speaking about legal and constitutional foundations of public policy. I really take that as a learning and appreciate that contribution. And the other one I noticed, and I would like to reiterate rather for the benefit of all of us, it was very interesting and convincing argument again from Professor Rajkumar. These days we know legal education is to lead to legal profession and to law jobs. It was so well put that legal education should cater to lawmaking. It is the public policy well conceived and well drafted in the statutes that seek to serve the public policy. If the job is done well there, I think half the job is done and courts will have very less job. And it was a very interesting and convincing argument. I am deeply convinced, and I would like to reiterate and press on this point that more and more public policy experts should come up. They should contribute to the policy making instead of contributing to the resolving of the disputes when they reach the court. Well, again, the idea of public policy is never new, ever growing, and fortunately it is receiving more and more importance today. It's the trending subject. It's there is no exaggeration if I say Dr. Roy has brought us the godsend opportunity. Let's all understand the importance of public policy, try to start our journey and travel a long distance in understanding public policy and trying to expertise in the area. I think with these reflections on this occasion, I once again strongly appeal to you, traverse more into the area, try to understand this subject more and more and be the beneficiaries. And let's all try to help the good governance of the country by understanding public policy. Thank you. Thank you very much.
Thank you for your kind and encouraging. Dr. Manoj Kumar B. Remote, kindly deliver the vote of thanks.
Thank you, Kaushankar. Respected dignitaries, my colleagues and dear students, Tuesday morning well spent for 1.5 hours by listening to Professor C. Rajkumar, who is known for his short and sweet talk issues relating to public policy. That is something very useful for us and gave a lot of food for thought for our students, I will say, sir. Thank you so much for raising the issue. And also, Tuesday thank Professor Sudarshan Ramaswamy, sir, who gave us nuances about public policy and how the Constitution of India has embedded these things. Thank you, Professor Sudarshan Ramaswamy, sir. And I also thank one more guest, Professor Ramanujam sir, for blessing the occasion. I thank Dr. J. Mallikarjunaya sir for providing us opportunity to listen to these great scholars. Thank you. Thank you.